Wow, it's mind-boggling. Your right to remain silent. Legal update on silencers. Owen Miller joins us today, Vice President of American Suppressor Association, and Chris Boeck, General Counsel for Silencer Shop. And I think everybody in this room will agree, this business is getting ready to explode here real soon. Guys, if you want to use one mic and one on here, you want to do that, or do you need a second mic?
No, I think one's fine.
Okay, you guys are good? Have at it. Thank you.
Back and forth. Sounds good. Good morning, everyone. I'm Owen Miller, the Vice President for the American Suppressor Association. I've been with the association about 9 years now. Prior to that, I spent 11 years working for a well-known major suppressor manufacturer, so I've been doing this for going on 2 decades now. And let's see here, this should be our clicker. So I think it's important as we start discussing some of the legal issues surrounding suppressors that you get an understanding of just how big is the suppressor market in the U.S. By show of hands, how many people live in a state where you can own suppressors? Okay, quite a few. As of right now, 42 states allow private ownership. We have the remaining hateful 8, the usual suspects that do not allow suppressor ownership. So about 82% of the country by states can own suppressors. So this is kind of what the market looks like over the last, I think that goes all the way back to 1990. So sorry that the writing is so small, but I'll try and fill in the gaps. So you can see kind of that hockey stick growth curve that the suppressor market has experienced over the last decade or so. And we've got one big blip there in 2016 that was associated with some rule changes. And then again, growing very rapidly, particularly in 2024 when transfer times came down dramatically. There you can see the average Form 4 transfer time for the better part of a decade or more. It hovered way up around 200 days. And in the last year, that has dropped down to single days. If anyone here has bought a suppressor in the last year, you've probably experienced some very rapid transfer times, usually under a week now. I think the median that ATF reports is 4 days for an approval of a Form 4. There again, eForm 4 average transfer time. So beginning in early 2024, you can see that rapid drop in transfer times. It happened a lot quicker for individual applications versus trusts, but recently those times have converged, so generally under a week. And then just an idea of how many transfers are happening. So several 100,000 transfers a year, with last year almost 750,000 suppressor transfers in the US. So rapid growth in the market, manufacturers doing everything they could to kind of keep up with that. And then this is a representation of the total number of suppressors that are registered with ATF. So as of the beginning of this year, it was about 4.4 million. I think by this point in the year, we have probably surpassed 5 million suppressors registered now. So considerable growth. And with that, I'm going to pass it over to Mr. Boeck.
Thank you. Appreciate it. Thank you. I'm Chris Boeck, General Counsel at Silencer Shop. And I want to talk to you for a few minutes about Second Amendment protection for silencers. And I want to say 2 things at the beginning here. It's not just about silencers, what I'm going to talk about. The tests that the courts are starting to apply to accessories and essentially anything that's not the weapon itself. So we're talking about silencers. We're also talking about optics and scopes and any other thing that's not a weapon but that you might feel should be protected by the Second Amendment. The other thing I'll say is it's shocking to see that every federal court so far has held that silencers are not protected by the Second Amendment. So we're going to talk a little bit about how they got there and going forward looking to the Supreme Court and what we might hope the test will be. So everyone in this room is familiar with this text. The language arms, bearable arms, is really what the courts are focusing in on, but I want to say one thing about this. Items don't have rights. People have rights. So when you're talking about whether silencers are protected by the Second Amendment, what you're really talking about is what conduct is protected by the Second Amendment. So the Supreme Court a few years ago laid out the Bruin test, which is the new standard for whether a statute or a restriction is constitutional. The first step, and that's really the one we're going to be talking about today, is the textual step. Is the item or the right or the conduct Does it implicate the Second Amendment? Is it implicated by the plain text of the Constitution? Only then do you get to the second stage where they ask whether or not the restriction is consistent with history and tradition. In D.C. v. Heller in 2008, the court specifically looked at the question of what is a bearable arm, the Supreme Court. And even though it's 2008, they explained that the question is a historical question, and what is considered an arm is the same now as what was considered an arm at the time from a definitional standpoint. So they looked at definitions at the time to get at the question of what did the drafters of the Constitution, what did the drafters of the amendment and those who were voting to ratify it think that the word arms meant at that time. And they laid out two definitions. Number one, weapons of offense or armor of defense. And again, these are colonial era definitions. The second being anything that a man wears for his defense or takes into his hands or useth in wrath to cast at or strike another. Then in Bruin a few years ago, we had the court refocus the attention of this question on conduct. The court said when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. And you can see from the analysis in Bruin, again, the focus is on the conduct, not the item. So the two tests I want to talk about today that the courts are using to find that silencers may not be protected by the Second Amendment are the necessity theory, and that's the main theory that the courts have been using up until very recently. And then what is now what I'm going to call archetype theory, and this is a new theory that a judge came up with this month, and we'll talk a little bit about that. So let's start with necessity theory. The state argues a silencer is not protected by the Second Amendment because it is neither a weapon nor necessary for the operation of a weapon. This test was used by the Fourth Circuit recently in the Salim case, where the court stated the silencer fails to serve a core purpose in the arm's function. That's a version of the necessity theory. Necessity theory fails for at least three reasons. Number one, it focuses on the item instead of the conduct at issue or the use of the item. Secondly, it leads to absurdity, which it allows the states to piecemeal regulate items out of existence to the point where you're left with essentially nothing. And then number three, it leads to the type of balancing test that the Supreme Court in Bruin rejected. And let me talk a second about that. Before Bruin, the courts engaged in a means-end balancing test when they were doing their Second Amendment analysis, where they looked at the goals of the government and they balanced them against the Second Amendment. In Bruin, one of the most important things the court said was this balancing test is not the appropriate mechanism. You should not be engaging in this balancing test. It's a judge empowering test. It lets the judges essentially insert their own opinions into the decision through this supposed balancing mechanism. So the first point, it focuses on the item rather than the conduct. In Heller, the court defined a bearable arm as anything that a man takes into his hands or useth in wrath to cast at or strike another. And the thing I'll point out here is you shouldn't be focusing on the thing, because Heller here is saying anything that a man takes into his hands or useth in wrath. So the question is, how is the thing being used? What is the conduct? A silencer really only has one use. It's not used as a paperweight. It's not used for really any other purpose than to attach to a firearm for the purpose of casting at or striking another. Necessity theory also fails under Bruin's analysis because Bruin, again, taught us to look at the conduct, not the thing, not the item. Necessity theory leads to absurdity. Here's one of the biggest problems with necessity theory. A firearm operates as a system of parts. And sure, if you take a firearm and you start removing a part here or there, you're going to end up with a dysfunctional firearm pretty quickly. But that's not the test that the courts are using. The courts are looking categorically. So they're saying this category of item, whether it's a stock, whether it's a forend, whatever the part is, whatever the component is, could you make a functional firearm without it? And it's hard to find very many parts that would pass that test. So what you're left with at best is a very, very rudimentary firearm. And in Heller and in Caetano, the stun gun case we'll talk about in a second, and in Bruin, the court was very clear that the Second Amendment protects modern firearms, not just the most rudimentary firearms. Another problem with the necessity theory is that it relies on the courts deciding how necessary is necessary. So for example, if you're looking at a stock, if you're looking at sights, let's talk about sights for a second, optics. Is it necessary for the firearm to function? No. You can absolutely shoot a firearm without sights. But does it facilitate the use of the firearm? Does it help it achieve its purpose of putting a round downrange at the intended target? Yes, absolutely. Is it necessary? That's the type of question we don't want the judges asking. And under Bruin, the court said that's not the right analysis. Let's talk for a second about the Peterson case. This is a case in the Fifth Circuit, which is a conservative court, and I and many others in the advocacy space were very excited about the Peterson case. The big question at issue is, are silencers protected by the Second Amendment? The original opinion from a conservative three-judge panel was incredibly disappointing. The opinion said, a suppressor by itself is not a weapon. Without being attached to a firearm, it would not be of much use for self-defense. And the court went on to talk about how it's not necessary for the firearm to operate. So the court essentially adopted the necessity theory. That's not the end of the story, though. The Peterson case got wild. After the court issued its opinion saying that silencers are not protected, an unnamed judge from the court quickly issued an order withholding the mandate. And that's a very unusual step. What that essentially means is someone on the court was saying, let's think about this. And what withholding the mandate means is the opinion has issued, but we're not going to let it go down to the district court level, be passed down to the trial court, which would normally be the next step. So someone one of the justices said, wait, let's hold this opinion back for just a second and think about it. The next interesting thing that happened was the Department of Justice filed a brief that said, court, please wait, hold off, don't do anything, we might actually change our position. And then a couple months later, they did file a brief and they said, we're changing our position. We now say silencers are protected by the Second Amendment. It was amazing. So within a month after that, the court withdrew the original opinion and everybody on our side was very excited. However, and this is a quote from the Department of Justice brief. It's amazing. I'm going to quickly skip through it because we don't have a lot of time, but essentially they said all the benefits of silencers, and then they pointed out the obvious point that they facilitate armed conduct, which is really the key test under Bruin. And they said, therefore, they should be protected under the Second Amendment. Here's the ruling we ended up with, though. Instead of running with what the Department of Justice had said, recognizing that the original opinion was flawed, the Fifth Circuit decided to simply sidestep the issue. So they issued a new opinion that said, we assume without deciding that suppressors constitute arms under the Second Amendment, as both parties now contend. So they basically said, everyone's in agreement, so we're not even going to touch that issue. Now, it sounds great. They're assuming that silencers are protected, but it has no legal precedent. So they were essentially avoiding the question, and it's not something that we can now rely on in future cases to say that the Fifth Circuit says silencers are protected. All we can say is the Fifth Circuit didn't answer the question. So let's talk briefly about archetype theory. Under the archetype theory, the state says a silencer is not protected by the Second Amendment because it did not evolve from an archetype existing during colonial times. Now, this theory is brand new this month. It came out September 5th, I believe, earlier this month, in the case of Anderson v. Raoul. And let me say really quickly, Anderson v. Raoul is a very important case to me, a very important case to Owen. This is a silencer shop and American Suppressor Association-backed lawsuit in Illinois. And we brought this lawsuit to test the question of whether silencers are protected by the Second Amendment. And I'll be clear, we expect this to go to the Supreme Court. We hope to get it to the Supreme Court. We don't expect to win this at the district court level. We don't expect to win it at the Seventh Circuit. We're hoping to take this to the Supreme Court. So we're not done yet. But the initial ruling we got from Judge Dugan in the Southern District, and he's a conservative judge, did not go the way we had hoped. He says, the difficulty with plaintiff's contention that silencers are arms is that unlike an AR-15 or AK-47 rifle, for example, plaintiff has not shown that silencers are modern forms of weapons known to be in use or available in the ratification period. And then he went on to explain his archetype theory. He says, simply, if there was no colonial era or antebellum period archetype to a modern day silencing device, it's difficult to understand how the framers would have understood the ordinary meaning of the word arms to include a device that reduces the report of a firearm. Anderson and Judge Dugan did a lot of really good things in his opinion. Frankly, it's actually not a terrible opinion on a lot of points. First of all, Judge Dugan rejected necessity theory. He said the Ninth Circuit reads the Second Amendment so strictly that it concluded that only those components necessary for the function of the weapon receive the amendment's protection. That view is not in keeping with the guidance of Heller and Bruin, so he rejected necessity theory. He also agreed that the question of whether an item is an accessory versus a firearm is not relevant. He pointed out that some suppressors are actually built into the firearm. They're integrated suppressors. So the question of whether it's a separate accessory or is part of the barrel or is permanently attached renders this question of whether it's an accessory irrelevant. He recognized that point. He even pointed out that certain accessories probably are protected by the Second Amendment. He pointed to removable magazines and sights and indicated that those likely are protected by the Second Amendment. And he agreed that the focus should be on the conduct and the use of the item at issue. So Judge Dugan was really on the right track with this case. But he struggled with the issue. He said, unfortunately, there is little helpful guidance that addresses the issues presented by defendant's Rule 12c motion. He was struggling with it. So he came up with his own theory. He said, plaintiffs do not point to a colonial era or Civil War years progenitor of a silencer or any device that was employed to reduce the report of a firearm, nor has there been apparently a period of evolution in silencer technology beginning in the 18th, or for that matter, the 19th century. So what he's saying is there wasn't an original silencer archetype back at the time of the framing, so it can't be a firearm at that time. Archetype theory fails for a number of reasons. Number one, it stifles innovation. In Rahimi, the Supreme Court recently said the Second Amendment is not a law trapped in amber. Here, with this idea that you can't consider anything protected unless it existed at the time of the Second Amendment, we are essentially trapping the Second Amendment in amber. The test is also arbitrarily narrow and unclear. So, for example, if his argument is you have to have something that existed at the time of the founding for it to be protected today, but we also know the Supreme Court says that stun guns and tasers and other electrical weapons are protected, where's the line? How do you distinguish between those two rulings? Another problem with it is that it focuses on the item and not the conduct. So, for example, the Seventh Circuit in Ezel held that firing ranges are protected by the Second Amendment because the conduct of becoming proficient with your firearms is a Second Amendment protected conduct. We also have cases saying that purchasing firearms, like the case, I believe it was Reese out of the Fifth Circuit, said that the conduct of purchasing firearms is protected by the Second Amendment. So the focus should be on the conduct, not on the item itself. And finally, it conflicts with Supreme Court precedent. In Bruin, the court said, although its meaning is fixed according to the understandings of those who ratified it, the Constitution can and must apply to circumstances beyond those the founders specifically anticipated. And look at that language, beyond those the founders specifically anticipated. That runs directly contradictory to Judge Dugan's thought that the founders needed to see something that existed at that time in order to contemplate the future weapons. He also said, or Bruin also said, thus, even though the Second Amendment's definition of arms is fixed according to its historical understanding, the general definition covers modern instruments that facilitate armed self-defense. And then there's the glaring problem of Caetano. Caetano was the Supreme Court case in which the Supreme Court said that stun guns or tasers are protected by the Second Amendment. And the Supreme Court essentially considered this archetype theory and rejected it. They said, in this case, the Supreme Judicial Court of Massachusetts upheld a Massachusetts law prohibiting the possession of stun guns after examining whether a stun gun is the type of weapon contemplated by Congress in 1789 as being protected by the Second Amendment. This is inconsistent with Heller's clear statement that the Second Amendment extends to arms that were not in existence at the time of the founding. So what is the correct test? I think the first thing to do when you're considering what the correct test is to remember that step one of Bruin simply asks the question, is the Second Amendment implicated? Are we talking about a Second Amendment issue? That's all it does. The proper test, in my opinion, and I think this is what we're going to be pushing at the Seventh Circuit and the Supreme Court, is does the instrument or the activity facilitate armed conduct? And I'll go back 2 slides if I can here, back to Bruin. You look at the last sentence there. The general definition covers modern instruments that facilitate armed self-defense. So this is not a new test. This is what the Supreme Court has already laid out in Bruin. And this is the test that we should be following. Pass off to Owen here to talk about the One Big Beautiful Bill.
So that's a lot to absorb, isn't it? So we're going to talk a little bit about the One Big Beautiful Bill. Cam, in his previous presentation, mentioned it, and how that bill, massive omnibus bill, affects suppressors and other NFA firearms. So this is Public Law 119-21. It was signed by the President on July 4th, 2025. And so the timeline for that, so the bill was introduced in May 2025 in the House as H.R. 1. And originally it included provisions of the Hearing Protection Act, which is one of our signature pieces of legislation, that would have removed suppressors from the purview of the NFA. So they would have become a traditional firearm controlled by the GCA, but no longer require the tax payment or the registration. We also included a fallback provision to simply reduce the tax to zero. And that, as we'll see as we talk about it further, was important to have that provision in there in case of an adverse ruling by the Senate parliamentarian as to what could be included in a reconciliation bill. As the bill moved over to the Senate side, the Senate Finance Committee added additional NFA firearms to that provision. So it would have also included short barrel rifles, short barrel shotguns, and AOWs. So this was part of a bill known as the Short Act to remove those from the NFA. Later on, the Senate parliamentarian unfortunately did rule against removal of these items from the NFA. However, she did rule that the reduction of tax to zero was germane to the bill and could remain. And so that passed both chambers. It was signed by the President, again, on July 4th, 2025. And so in the final version, what it does is, beginning January 1st, it will reduce the transfer or making tax on those NFA firearms to zero, so no longer require payment of the tax. It does, however, unfortunately retain the NFA registration requirements. And then the process to acquire those firearms is unchanged, so still a Form 4 with fingerprints and photographs. There are some, and I'll step back a second. What that did now with the $0 tax is it has opened up an opportunity for us to challenge the constitutionality of the NFA. The NFA was upheld in 1937 as a revenue-generating measure. And the registration component of that was upheld simply as a means to determine who had paid the tax. So now that there is going to be no more tax, it calls into question the validity of the registration requirement. So we have filed, ASA, along with our partners, including Second Amendment Foundation, have filed suit in the Eastern District of Missouri to challenge the constitutionality of the NFA, and that's along with Silencer Shop. Silencer Shop is also part of another lawsuit in Texas, and I think we have some slides to talk about that here in a minute. But there are multiple suits now challenging whether or not the NFA will stand without the tax. Along with that, we are keeping an eye on some state law issues. There's about 17 states that have various languages within their state laws that speak to suppressor ownership, requiring registration with the NFA, requiring compliance with federal law, things like that. So we're keeping an eye on those states, and we'll be taking action preemptively to make sure that if the NFA falls or if suppressors come out of the NFA, that doesn't affect ownership in the states that do allow them, that have those provisions in state law. So again, litigation against the NFA. I think I'll pass this back over to Chris.
Yeah, appreciate it. So we're running out of time. So just quickly, we've got 2 different lawsuits we filed this year. Silencer Shop Foundation versus ATF and Chris Brown versus ATF. Chris Brown versus ATF is joined by American Suppressor Association as well. And we've got 15 states joined in on this as well. We've got Texas and about 14 other states. So it's a big fight. And the argument essentially is once you've got the NFA that is based on this idea that Congress has taxing jurisdiction. Once you drop the tax to $0, you've got a tax that doesn't actually tax. So you lose the taxing jurisdiction, and there's no reason why you should still be registering and creating lists and requiring fingerprints for silencers, SBRs, short barrel rifles. So that we filed these lawsuits to challenge the NFA under that provision. Goal we just talked about. We've got two claims. One is based on the taxing power. The other is based on the idea that you should not be taxing a Second Amendment right? So we're going to test that theory as well. Let me pass back. Sorry for the back and forth here.
So as part of ASA's goal to legalize suppressor ownership in all 50 states, that also extends to the territories of the U.S., so Guam and Puerto Rico. So I'm happy to announce that as of July, we helped secure legalization of suppressor ownership in Guam. And so it's the first territory to legalize civilian ownership. It was originally passed in 2021, but the territorial governor vetoed that legislation. It was passed again in 2025 with bipartisan support. So Guam's legislature, it's a 15-member legislature, but it included Democrats in passage of that bill. It was vetoed again by the governor. However, this time the veto was overruled. They had a veto-proof majority. Oddly enough, Guam is not subject to the U.S. tax code, so we're working through some interesting nuances there that they are not subject to the NFA registration and tax requirements. So moving suppressors from the NFA in the U.S. Is essentially an export, even though it's a U.S. territory. So we're excited about that, and that opens the door for other legalization pushes, hopefully in Puerto Rico, as well as bracketing Hawaii in there because they're kind of sandwiched between places that they're now legal. And now back to Chris.
It's the last switch, I promise. I just wanted to talk really quickly about the NFA process as it currently stands and as we'll see it starting January 1st. So the big beautiful bill, as we talked about, eliminates the $200 tax for purchasing silencers. Unfortunately, at this point, it doesn't eliminate the fingerprinting and the other registration requirements, but Silencer Shop has designed a system to try to make that as easy as possible. We've got essentially a three-step process. Find your silencer, set up a profile, and then sign and certify. We've created a system that lets you certify your forms with the government from your couch. So you can essentially buy your silencer from the website, pick it up at your local dealer. One of the biggest points of our business model is we want to support local dealers. We're not trying to circumvent the dealer. So every silencer you buy from us is going to go through one of we have, I think, about 6,000 powered by Silencer Shop dealers at this point across the country. So you go to the website, you pick out the silencer you want. We've got people that can talk to you about what caliber you're looking for. What are your goals with your silencer? Are you going to want to go hunting with it? Do you want something incredibly light, backpacking? Do you want long range precision? What sort of caliber are you using? We can answer the question you might have about what silencer do you need. And then setting up the profile is super easy. It can be done, again, from your couch. We've got kiosks all over the country that take care of the fingerprints. Thousands of kiosks. I'm sure there's one nearby, almost every one of you. You put your fingerprints in, and you never have to do that again. So it's not like going to a wet ink fingerprint location where you've got to get your fingerprints dirty and then you've got to do it the next time you want to buy a silencer. It's scanned, it's digitized, you never have to worry about that again. Then you sign and certify from your couch, and you pick it up at your local dealer. So we want to make it simple. Starting January 1st, there is no tax on silencers, so your $200 that you used to pay goes away. We also are looking forward to continued low wait times. We're working with ATF to make sure they're ready to handle the volumes that we expect to happen starting January 1st. They've assured us they have processes in place. In fact, they're revamping their e-form system and getting ready for this new January 1st influx of what they expect to be a huge wave of new NFA purchases of silencers and SBRs. We're looking at a complete ratification or a complete redo of their system, and we're excited to work with them on that front and make sure that we can keep the market moving and make sure we can get everybody a silencer who wants one. And with that, I appreciate your time. Thank you so much, and grateful to be here.